professor at the Auckland School of Law, but also the president of the Animal Law Association, and it's my great pleasure to be with you today, as well to talk about the Animal Welfare Act 1999. How's the sound at the back? I heard that you weren't so good. Yeah, lots of thumbs up. That's fantastic. I hope you had a great morning tea. I was just talking to Elliot from Greenpeace over the morning tea break, and I said, you know, this is what I'm doing. He's like, oh, right, you're the one that's doing the boring but important one. And it was a nice encapsulation of what I'm about to talk to you for the next 30 minutes, hopefully with about sort of 15 minutes of questions. Yeah, the law is often sort of the boring part of any aspect of fighting for animal liberation, but it's crucially important. I think we've already sort of seen a few examples of just how powerful the law can be today. So the sort of the end of greyhound racing in New Zealand came through sort of legislation. The end of live export of animals by sea came through a legislative ban. And these are important wins, often the sort of the icing of the cake after years of hard grift through activism and hard work through people like yourselves. But you've often also seen law getting in the way of things, right? Tara Jackson talking about sort of the frustrations of the outdated Part 6 of the Animal Welfare Act. You know, the Auckland, oh dear. I saw something going on in the background. I hope it wasn't me. That's good fun. My pleasure. Yeah, so the fact that sort of Auckland Zoo Action have had to use the law to try and sort of get access, but are also sort of pretty frustrated when they see something called a code of welfare, clearly not protecting those giraffes in the rain. It's really clear, sorry folks, this is land by itself. We can get some people to do this. I swear I'm not doing this. I think it might be on autoplay or something like that. If you guys could sort of sort that out, that'd be A++. Cool. So, point being, law can be used for good, and it can be used for bad, but whatever it's used for, you need to know about it, yeah? I think a lot of forces that are keeping animals in the situation that they're in at the moment basically depend upon the complexity of something like the Animal Welfare Act to their advantage. They use it in a way that makes it essentially difficult for people on the street, folks that don't have a lot of sort of usual interest in the issues of affecting animals. They use it in a way that makes it very difficult to sort of understand how our farming systems and animal welfare systems work in this country. And so long as that becomes complex and opaque, it's going to make it very difficult to achieve real change. So my aim for the next sort of 30 minutes is essentially to try and provide a bit of a primer to all of you to understand how our core piece of animal welfare legislation in this country works. As I say, I'll talk to you about 3 different things for about 30 minutes, and then hopefully sort of open it for some questioning, just so that we can get all on the same page. Now, can we start the presentation? Not autonomously, let's see. I want to do 3 things. First, I want to talk to you about where we are, but how we got here, and sort of the history behind the Animal Welfare Act 1999. Then I want to talk to you about what it's doing well and what it's not doing so well, and basically how that operation of the Act works. And then finally, what I want to talk to you about is what needs to change in that legislative environment. So if we zoom through the history pretty quickly, it seems like an odd place to start, but at the same time, I think it'll become pretty illustrative of why I want to sort of mention it. Our first Indigenous piece of legislation relating to sort of animal welfare or animal cruelty was in 1878. It was basically borrowed hook, line and sinker from early legislation in the UK. And this Act, this is a screenshot of it here, basically had a very sort of simple task. It basically outlawed the improper slaughtering or carrying of animals. It said that any person who's slaughtering, branding, conveying or carrying or causing someone to do that in a way that causes an animal, quote, unnecessary pain or suffering, that will be held to be ill treatment of an animal. It was the the first time in New Zealand that it was criminalised. The most modern sort of facsimile of that sort of took place in the mid-1960s was something called the Animal Protection Act. That was the forerunner to the act that we've got now. As you can see, it's in a very similar state to that sort of 1878 legislation. It defines ill-treat in a little bit more of a broader way. Beating, whipping, kicking, wounding, maiming, abusing, worrying, tormenting, torturing, terrifying, infuriating. So they just threw a thesaurus into the legislation rather than actually sort of thinking about it. But those sorts of aspects towards an animal were deemed to be ill treatment. But it only became cruelty when that ill treatment was inflicted in an unreasonable or unnecessary way. Those words will come back later on. The Animal Protection Act existed for about sort of 40 years, and it was woefully inadequate for lots of different reasons. Pete Hodgson, who was an MP in the Labour opposition in the 1990s, worked with the sort of the national government to try and sort of change that legislation. And he said in Parliament, quote, that the Animal Welfare Act, the new act that we've got now, replaces the old legislation that is now nearly 40 years old. The legislation that it replaces is, quote, a crock of old garbage. Back then in the 1999, that was considered to be sort of like as bad as you could get in Parliament. How times have changed. It is no good for animal welfare, it is no good for animal ethics, it is no good for a nation that trades in animal products to the extent that we trade in this legislation that is terribly out of date. Now that emphasis on trade is important because the only reason, by the way, that this legislation was changed is because there was a threatened boycott by the EU of New Zealand products given our terrible animal protection legislation as it existed. So it was really only sort of economic and trade interests that forced New Zealand to sort of update its animal welfare legislation. And nevertheless, when we did get that Animal Welfare Act, the one that we have now in 1999, it made headlines. It was by far the most progressive animal welfare legislation in the world, recognising something called the 5 freedoms, which I'll get into in a short time, banning the testing on great apes, for instance. A lot of really sort of progressive aspects within the Act were there, such that it made international headlines. So what does it do? What is the Animal Welfare Act 1999 and how does it work? Well, the key parts, you've already seen this, but the key parts in my mind are parts 1 and 2 of the Act. Part 1 of the Act talks about care of animals and it imposes duties on those who either own or are in charge of animals. So anyone who has a companion animal will have the duties that are imposed upon them by Part 1 of the Act. But anyone who is in charge doesn't necessarily have to own the animal of an animal, whether it be a companion animal or a production animal, will also have these duties. Part 2 applies to all of us, though. It doesn't matter if you own or are in charge of an animal, you are not allowed to engage in ill treatment of any animal, regardless of whether or not you have a pre-existing relationship with them. Part 1 seems pretty straightforward and seems pretty easy to understand from the get-go. Section 10 of the Act imposes broad duties on anyone who owns or is in charge of an animal to ensure that their physical health and behavioural needs are met. A failure to do that attracts a potential penalty of up to $50,000 for an individual, up to a 12-month sentence of imprisonment. Section 4 of the Act defines what those physical health and behavioural needs are. And this is where the 5 freedoms comes in. 5 freedoms was sort of established in the 1960s as the base level of what animals need to have a good life. And that's recognised in legislation. We were the first country to do this. And they're really, really basic, right? Those physical health and behavioural needs include proper and sufficient food and water, adequate shelter, the opportunity to display normal patterns of behaviour, physical handling in a manner which minimises the likelihood of unreasonable or unnecessary pain and distress, and protection from and rapid diagnosis of any significant injury or disease. That's all with the rider of it being appropriate to the species, environment, and circumstances of the animal. Now, I hope that you're all sort of wondering, how on earth were we allowed to have Ferrere crates that allowed a mother pig not to turn around and to be behind sort of bars, not really sort of being able to do anything that she wants to do, especially the opportunity to display normal patterns of behaviour. How on earth can we have hens in colony cages, stacked sort of 8 to a cage, not really being able to do any sort of degree of foraging in a barn and not outside? How are we allowing giraffes to be in Auckland Zoo, not really having any degree of shelter from the elements? How are we allowing that poor tortoise desperately trying to sort of get out and engaging in all sorts of behaviours that indicates that it's clearly sort of stressed? Well, there are a couple of reasons as to why these duties exist, but they don't necessarily sort of attach in those sorts of situations. One of the reasons I'll talk to a bit later, and that is to speak about sort of issues of enforcement. But another big reason is the way that these general standards are actually fleshed out. Because there is a defence in the law that says that if you comply with a relevant code of welfare, then you are deemed to essentially comply with those broad duties that are within the Act. And that means that codes of welfare, which sit separate to, but under the general provisions of the Animal Welfare Act, are super important. You actually already have seen a code of welfare provisions. The Auckland Zoo actually did me a great service by sort of just showing that there was a clear sort of code of welfare relating to sort of the treatment of zoo animals. That is informing what those general standards within the Act actually mean. Now, these codes of welfare, and in addition to making them complex, this is why this is so tricky to explain, specific sort of regulations, these help sort of inform exactly how the Animal Welfare Act works in practice. The standards that you'll find in both sort of regulations and the code of welfare that apply, and by the way, codes of welfare, there are 18 of them, they apply in all sorts of different situations, from llamas and alpacas to zoos to companion cats to commercial slaughter of animals and rodeo. These standards are set by a body called the National Animal Welfare Advisory Committee, or NAWAC. They, through sort of engaging and sort of looking at the best possible science and lots of sort of public consultation, come up with some standards that they think are the best sort of, or the appropriate sort of use or industry to which the animals relate. And those standards that get put to the minister, and then they get sort of produced as a sort of a code of welfare. They provide both minimum standards and recommended best practices. Now, in the same way as compliance with the code of welfare means that you've got a good defence against any charge that you're not actually complying with your duties, they also provide evidence of a breach of the Animal Welfare Act. So if you do not meet those minimum standards, it's not an offence, but it can be used as evidence of offending in any sort of prosecution. Regulations operating in addition to that are much easier to enforce. They can essentially work in parallel, creating directly enforceable standards. So if you leave your dog in a hot car and it starts to exhibit sort of behaviours that indicate that it's undertaking heat stress, you will receive an infringement. Hopefully you will receive an infringement notice just in the same way as you might receive a speeding ticket. That operates separate to these codes of welfare. So, the minimum standards in codes and regulations must comply with the general purpose of the Animal Welfare Act. The general idea is that you shouldn't have codes of welfare that fall below what's required by the Animal Welfare Act. And yet that's exactly what had happened for a long, long time. Deborah from SAFE mentioned the case about sort of Ferrere crates. This was exactly the provision that it was looking at. It was basically arguing that a code of welfare which permitted Ferrere crates couldn't possibly meet the general purposes of the Act. Why? Because as I mentioned, Ferrere crates which prevent a sow from being able to turn around can't possibly provide for the sow's capacity to exhibit normal patterns of behaviour. And so the New Zealand Animal Law Association, but led by SAFE, took this case to court, basically saying that the code of welfare that allowed for these Ferrere crates can't be legal, can't be within the scope of the Animal Welfare Act. And the judge agreed, basically saying, well, clearly this isn't sort of meeting the purpose of the Act. In fact, NZALA had, the body that sort of recommended, had on several occasions said that this did not meet the requirements of the Act. If in a situation like that occurs, you can phase them out, but you can't have them for a long period of time for indefinitely. So after that case happened, the government sort of agreed that it needed to phase that practice out. And that phase out of farrowing crates was supposed to occur on the 19th of December 2025, because the government had given itself 5 years to basically transition away from farrowing crates. But the nature of our constitution in this country and the way that it works, Parliament always has the capacity to override that. Now, they shouldn't, right? There is a strong moral case that what they would be doing if they overrode this would be not only going against the wishes of those pigs and the various sort of activists that had sort of challenged those, but also against the sort of the best evidence from NZALA, from all of those independent bodies, from the intention of the Animal Welfare Act itself, and all of the many thousands of people that have sort of contributed and been consulted with to establishing those standards. But Parliament can nevertheless, as we've learned in this term over and over again, do whatever it wants, so long as the government has a clear majority in the House. And that's why we saw at the end of last year, the Animal Welfare open bracket Regulation for Management of Pigs, close bracket Amendment Act 2025. Easily, in my mind, one of the worst pieces of legislation that we've had just generally, but certainly the single most regressive piece of legislation with regards to sort of animal interests and animal rights in New Zealand's history. Because throughout the history of our relationship with animals in this country, there's been slow progress, but it's always been progress, right? It's always been one step, slowly, one foot in front of the other, trying to get a better deal for animals. This is deliberately making mother sows stay in cages indefinitely, right? And that was a change from the law that we had, the phase out that was going to happen. It is an absolute shameful mark on this government and unfortunately our animal welfare and animal rights record within this country. You can see the cynicism. I mentioned that the phase out was going to occur on the 19th of December. This became law on the 16th of December, 3 days before that phase out was going to happen, 3 days before farrowing crates would have become illegal in this country. So there is a deep, deep cynical aspect to this particular piece of legislation, showing that the law can be used for ill just as well as it can be used for good. So that's part one. It's complicated in the sense that you have these general duties on anyone who owns an animal or is in charge of an animal. That makes sense. It gets complicated once you start looking at the different sort of specific standards that come in codes of welfare and regulations, but also the fact that government and Parliament can sort of override them with a stroke of a pen. Part two, and ill treatment, is a little bit more straightforward to explain. It defines ill treatment as essentially causing by any act or omission pain or distress in its kind of degree or in its object or in circumstances which is inflicted, unreasonable or unnecessary. A horrendous but really sort of current example of this is the man who allegedly basically caused all sorts of mayhem at Manukau Road earlier this week. I'm sure that many of you will be aware that part of that mayhem included the strangulation of a dog to death. And he has been charged with willful ill treatment of an animal, because the causing of the pain and suffering there was entirely sort of unreasonable or unnecessary in the circumstances. But of course, we can sort of contrast this to, again, why are mother pigs in cages? Well, because that's deemed to be sort of necessary and reasonable, right? So those two words do a lot of heavy lifting, and have been doing a whole lot of heavy lifting since 1878, because if you can remember, this is basically the same definition that we had all the way back in 1878. This perpetuation of the idea of what ill treatment is, what animal cruelty is, basically pain and suffering that is unreasonable or unnecessary. Not just pain and suffering itself, but pain and suffering that is unreasonable and unnecessary means that it's going to change according to the circumstances of the animal and the use they're put to. So that's why your treatment of your companion cat, if you started to do the sort of things that you would do to, say, a cow, a sheep, or a pig, that would be ill treatment. But obviously it's not ill treatment of the cow, sheep, and pig, because that is an industry standard. Society broadly accepts that sort of treatment of farm animals is legitimate, and that's why that is reasonable and necessary, therefore not ill treatment. Whereas if you did that to any other animal, it would definitely be ill treatment. Try docking the tail of your cat without anaesthetic just to try that out, right? That would be willful ill treatment, the worst offence in the Act, but it is something that we obviously routinely do to sheep on a yearly basis. So, there are 3 levels of seriousness. If you simply cause pain and distress that's unreasonable or unnecessary, that is what we would call the lowest level of ill treatment. You don't need to intend to cause pain and distress, and that's why it's the lowest. If you're reckless with regards to your actions and it leads to the same outcome, or intended to do it like the guy on Manukau Road did, they increase in seriousness right up to the most serious level of offending, 5 years imprisonment or a $100,000 fine. So, those are the 2 major parts of the Act. One is about the duties that you have as an animal owner. One is relating to the conduct that we all need to exhibit towards animals on a daily basis. But there's lots of other stuff within the Act as well. There's a lot of symbolism within the Act. Under the long title of the Act, the one basically explaining the purpose and the intent of the legislation, it recognises that animals are sentient, which is awesome. It also elsewhere in the Act prohibits cosmetic testing of animals and presumptively bans research involving non-human hominids. Those great apes that I talked about. We've never engaged in cosmetic testing in animals, nor have we involved research involving great apes in this country, but nevertheless it's good that we've essentially banned that from happening in the future. As Tara from Beyond Animal Research was talking about, Part 6 is crucially important. That is the regime that talks about animals involved in research, testing and teaching. As she mentioned, it's carved out entirely from the Act. So when I talk about ill treatment or the duties towards animals, they simply don't apply to animals that are used in research, testing and teaching, and that's why that can occur. And there are also specific bespoke sections, like the banning of live exports by sea, which has been secured and will be safe in law, I think, for time immemorial now, cross fingers. Section 41 prevents that from actually being, from ever occurring. So there are lots of little different other aspects within the Act that are important. Now I want to sort of shift as to sort of what it doesn't say, essentially, but could and would make a huge difference to animal lives if so. I don't know why I sort of just gravitate towards sort of microwave ovens as sort of as the product of choice. I don't know what that says about me and that sort of stuff, but animals aren't microwave ovens, obviously, right? And yet in the law they are, right? And what I mean by that is that the fundamental problem that underlies the Act and basically the way that we treat animals in our relationship with animals in society today is that the law treats them as what we would call chattels. Now, if you've ever bought or sold a house, congratulations to you. I'd love to know that how that's like. But there's a chattel list at the end, right? And these are the things that come with the house: an oven, curtains, or whatever. Chattels are simply sort of movable property. And in the law, animals are chattels. In fact, the word chattel comes from the same derivation of cattle, right? It's always been this idea that animals are property. So although they aren't microwave ovens, in the law, they have the same status as microwave ovens. The big difference between a microwave oven and an animal, if you didn't know, is that the animal has a brain, right? And has sentience, as the Act actually recognises. And yet, because we treat them as property, and because we sort of conflate them with inanimate objects that can't feel pain and can't experience joy, we have always this block which basically prevents us from seeing animals for what they are and allows us to treat them according to our wishes and not necessarily theirs. That's the fundamental problem that exists. Now, the Animal Welfare Act could deal with that, but instead it sort of silently acknowledges that animals are property in the sense that they can be owned by us. And that is the big problem. It's this classification that allows us to do anything we want with animals so long as it's reasonable or necessary. The Act puts a strong barrier. If you treat an animal that causes them pain and distress that isn't reasonable or necessary, then that's going to attract attention and it will create an offence. But as long as it's reasonable and necessary, you can do whatever you want with an animal. And that's the core reason that we see so much systemic and institutionalized cruelty towards animals in this country. The other thing that the Act tends to sort of get wrong and does a poor job at sort of really engaging in is an idea about enforcement. And this is where that great example about the giraffes in the rain comes to play. The story is that Auckland Zoo Action went to different agencies and said, hey, this is a breach of the Act because it's a breach of the Code of Welfare, therefore evidence that the Act isn't being met. 100% textbook example of the Act being breached there, by the way. But what agency did they go to? Because there is, the Ministry for Primary Industries, which enforces the Act. The SPCA also has a crucial role in enforcing the Act. And the police have the capacity to enforce the Act. But what tends to happen is that the SPCA gets lumped with a lot of responsibility, operating on an extraordinarily shoestring budget, most of which is not publicly funded. They are, of course, a charity, and yet often have the lion's share, so to speak, of actually enforcing the Act. That's especially when it comes to sort of companion animals. MPI has sort of the responsibility when it comes to sort of production animals, but they have around sort of 30 animal welfare inspectors for over 150 million production animals in this country. They are also pretty under-resourced. And when it comes to a giraffe, I can see why they were bounced from agency to agency, because what is a giraffe? Is it well, I know what a giraffe is, it wasn't a rhetorical question, but is it a companion animal? Is it a production animal? It's neither, really. And so it's really unclear as to exactly who would have jurisdiction. Technically, the police should be able to go in there and actually sort of rescue the giraffes. But of course they're not going to. They will always deny responsibility for that situation. And so although the Act says a lot of good things, often the enforcement of the Act is a core problem as to where it sort of falls down. Because the Act also deems police to be animal welfare inspectors, they should take a much greater responsibility. But as I just said, they often sort of deny any sort of responsibility to enforce the Act as it applies to sort of animals. In practice, it's really only MPI and SPCA who enforce the Act and do so with very limited resources. And that creates all sorts of big problems. It means that we see animal welfare offending occur on a daily basis, but no one does anything about it. And that gives signals to the rest of society that it's just not important, it's just not serious enough. And that in turn sort of creates itself a perpetuation of this problem. As we also saw through the sort of the Baron Crates example, the whole reason that occurred, by the way, is because there was an incredible amount of pressure and engagement with the pork industry in New Zealand. They didn't want this phase out to occur. The Minister of Agriculture was a mate of theirs and had former staff in his office. There is an insane amount of regulatory capture going on driving policy. NAWAC is theoretically independent, but really under-resourced, and that means that folk in this room, folks like my organisation, the New Zealand Animal Law Association, and SAFE, are at a complete systemic disadvantage because we don't have insiders in government. We don't have people on Andrew Hogarth, what a rolled up villain he is. We don't have staff within his office, right? And as a result, we are at a systemic disadvantage because of well-resourced industry interests. So, to conclude, before we consider break to some questions, the Animal Welfare Act 1999 justifiably lauded as a groundbreaking, world-leading legislation, the most progressive piece of legislation of its type in the world when it was enacted. But it's one foot in the past now. So Pete Hodgson said it was a crock of old garbage referring to the previous legislation. I could say something similar about the Animal Welfare Act now. It suffers from inherent and fatal flaws about the way that we recognise and treat animals within this country. So if we really wanted to put the interests and rights of animals first, we need to start from scratch. It's going to be a long road to get there, but I hope that you wonderful, wonderful people that have given up your Saturday to come here and sort of coordinate with all of us about how to change this, I hope that we can make it happen. Thanks very much.